Hello, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And I am very happy to be back here with you all talking about law and video games and everything in between. So with that as our introduction, we have a lot to talk about today. So let's get to it. First and foremost, if you aren't familiar with anything related to this story, congratulations, you've avoided most of the video game discourse on the internet. But also, I wanted to point you to a video I did earlier this year called Is PalWorld Legal?, where I was fielding a number of questions regarding copyright law and whether or not the designs like the one you see on the thumbnail here were too close to the sun of what Nintendo designs for their own Pokemon, and that they were going to get in trouble, the people that make PalWorld, PocketPair, for having these designs be so close. And I had a long video. We talked about all these issues, and I said that copyright is not infringed just by vibes, right? You can't just protect the way a certain animal curves, the concept of an electric mouse, and the various other things that people on the internet were saying were violated by the existence of PalWorld. What I didn't talk about was patent law, which is what we're going to talk about today, because it wasn't really pertinent when people were discussing whether or not characters like the one you see here were violative of Nintendo's intellectual property. But lo and behold, about 10 days ago, Nintendo announced that they were filing a lawsuit against PocketPair. What were they filing a lawsuit for? Well, as they say in their headline, infringement of patent rights. Nintendo Company, together with the Pokemon Company, filed a patent infringement lawsuit in the Tokyo District Court against PocketPair Inc. on September 18th, 2024. And here's where I give one of my disclaimers that we'll have in this video, and I have a couple of them. The first of which is that I'm an American lawyer. I am licensed to practice law in the state of Michigan. I do software and business law, and I have discussed intellectual property with some of the biggest companies in the country and some of the smallest companies in the country. But I do not practice law in the country of Japan, and every country is going to have little interesting procedural issues that are going to be unique to that locale. If you were to come to me in my office and say, Rick, I've got a patent infringement lawsuit proceeding in the Tokyo District Court, I would tell you to find local counsel that knows the ins and outs of Japanese patent law before you went through with that lawsuit. But we can talk in more high-level generalities here on YouTube, and we can talk about some articles and other research that I have found with respect to Japanese law to understand better how our understanding of United States patent law and patents in general can help inform how the Japanese court system might see this issue. But proceeding with the press release from Nintendo, this lawsuit seeks an injunction against infringement and compensation for damages on the grounds that PalWorld, a game developed and released by the defendant, infringes multiple patent rights. Now, interestingly, this jumped out at me as soon as I saw this press release, because this is where you would ordinarily tell the world what patents you think are infringed, right? The fact that Nintendo doesn't say that here is interesting to me. Certainly reading it, you could suggest that Nintendo doesn't want the public to think about what patents it's alleging to have been infringed, or that it doesn't want PocketPair to know what it is alleged to be infringed. And we'll see in PocketPair's statement in just a minute that PocketPair, as of the day of this filing and the day after, was not able to tell you which patents were alleged to be infringed. And that's important because unlike a copyright claim, and we're going to get into the differences of this intellectual property, if this is going already too fast and confusing for you, I don't blame you. If this were a copyright infringement claim, it would be patently obvious. And I don't mean to use the word patently in this context because that's even more confusing, but it would be obvious on its face that what Nintendo was alleging was essentially designs being stolen, the art of Pokemon being stolen to be put in something like PalWorld. The fact that they are instead alleging patent infringement suggests a couple of things. One, like I said in my earlier video, and like a number of people said online when people were arguing about it, there was no obvious asset stealing in PalWorld, and PalWorld's a very different game from Pokemon, so it is not an obvious case of copyright infringement, and it would appear that since copyright infringement would be more valuable to Nintendo, that Nintendo has said, we're not going to seek a copyright infringement claim, we're instead going to go this patent direction. And because of that, I think we're looking at a much narrower danger for PocketPair and PalWorld, and if you take nothing else away from this video, I would say you should take this. In my opinion, it is very likely that if you enjoy PalWorld as it is right now, PalWorld in a substantially similar capacity will exist for you into the future. You'll see articles talking about Nintendo's danger here. You'll see articles talking about Nintendo winning all of its intellectual property cases that it voluntarily brings and all these various things. But winning is in the eye of the beholder somewhat. And while PocketPair might well wind up owing money or some other settlement obligation to Nintendo as part of this, we don't really know because we haven't seen what patents are alleged to be infringed as of yet. It is likely the case that what is going to happen here is not the complete removal of PalWorld, but potentially smallish changes to make sure that it's not infringing and some settlement amount with Nintendo. I can't promise that. Nobody can guarantee these things when they look at it from a legal perspective. But if you take nothing else away, if you're a fan of PalWorld and what they represent, my opinion here is that looking at a patent case of this type and of the type that people have identified in the various rumors and innuendo around the gaming industry is suggestive to me of a PalWorld that can succeed and can exist into the future, perhaps with some small changes that probably won't materially affect your enjoyment of that product if you like PalWorld. So I wanted to get that out there out front because I think that's an important message to send. There's a lot of people with doom and gloom out there saying Nintendo's going to destroy them. Nintendo planned this for 8 months and they're going to kill them. And they certainly are seeking a pound of flesh. That is undoubtedly the case. That's why this lawsuit gets filed. But I don't think this is a PalWorld killer at the end of the day. Nintendo finishes with an interesting statement. They say they will continue to take necessary actions against any infringement of its intellectual property rights, including the Nintendo brand itself, which is not at issue here and wouldn't be at issue in a patent case. So it's odd to add in this context, but hey, to protect the intellectual properties it has worked hard to establish over the years. And so that's the lawsuit that came out. A number of people that were expecting Nintendo to sue over this kind of quickly and erroneously reported it as a copyright infringement lawsuit because that's what we were expecting. But it is a patent lawsuit. It is a narrowly focused lawsuit on specific patents. We don't know what those patents are yet, but journalists have gone out and tried to figure out what the patents are. There are some good guesses out there that we will talk about as part of this video. But in general, because they are going to be so directed at specific mechanics in a video game, those mechanics can be changed, the product can survive, and perhaps PocketPair will owe an amount of damages in settlement to Nintendo. I certainly don't see this lawsuit proceeding for years and years and years and everybody spending millions of dollars on lawyers. I think it's much more likely to settle like almost all civil lawsuits are, but we will certainly see as this story continues. Now, on that score, I did want to mention to folks before we get into the specifics of law and patent and everything else, that this is a channel supported by viewers and listeners like you if you're listening to it in podcast. If you are live, we will be talking about super chats and membership comments and various things, especially during the questions and comments section at the end of this video. But if you're not live and you're watching this in replay or on podcast, leave a comment and I will try to get to as many of them as I can to answer questions and hopefully add to the information in the universe about this topic. Because if Virtual Legality stands for anything, it is wanting to get more and better information out there so that we can avoid some of the confusion around these topics from well-meaning people that just misunderstand certain key aspects of what these stories are about. Now, on that score, let's talk about the difference between trademark, patent, and copyright from the United States Patent and Trademark Office. Now, we're going to use the U.S. because, again, I'm licensed in the United States to practice law, but also because the way intellectual property works, because we have these multinational corporations that sell things across borders, treaties and various other international legal mechanisms are used to make sure that trademarks, patents, copyrights, intellectual property in general are acknowledged by most of the jurisdictions that companies would care about. So when we talk about these differences in the United States, these differences are going to survive in large part in various jurisdictions, including Japan. Where they differ is that, like in the United States, we have courts and the USPTO and various other regulatory bodies evaluating these definitions and what they mean in our jurisdiction, the United States. Every other jurisdiction is going to interpret them their own way and have their own procedures towards doing that. And we will see in just a minute how Japan differs in a way that might advantage Nintendo. But trademarks, as we see here from the USPTO, are words, phrases, and designs that identify your goods or services. What's an example for that? They say Coca-Cola, right? These are the brands that we think about. A patent, by comparison, is an invention, such as a chemical composition like pharmaceutical drugs, mechanical processes like complex machinery, or machine designs that are new, unique, and usable in some type of industry. Now, patents also incorporate certain design elements, but the U.S. Supreme Court has been very careful, or at least tried to be very careful, in telling companies that they can't just get around the fact that a copyright can't be applied to an idea by patenting kind of the design of that idea and then suing others over infringement of that design. So this gets a little bit technical here, but patents are for inventions. They are for novel ideas that are presented in a new way that industry can use to better further its development in some form or fashion. Copyright, which is what we usually talk about in virtual legality with respect to video games and movies and whatnot, is protections of artistic, literary, or intellectually created works such as novels, music, movies, software, photographs, and paintings, right? This is the creative act. This is Pokemon as a whole, the concept of the Pokemon video game. The way a Pikachu looks, that is copyrighted. It's not patented. But there are aspects of how a game is made that can be patented that we've talked about in this space before, including with respect to the Nemesis system that Warner Brothers patented for its Middle-earth series of games. And so there can be cases where you want to encourage video game developers, software producers, if they're in more serious enterprise-level software making, to be able to control an invention that they make because we want to encourage those inventions to exist. Or, as the Federalist Papers said, with respect to the constitutional authority given to Congress to create these various monopolies, the utility of this power will scarcely be questioned. Now, I think that's probably a little bit narrowly focused. I think it's questioned quite a lot right now, but that's for policy reasons that talk about how long a copyright lasts, how long a patent lasts, etc. The copyright of authors has been solemnly adjudged in Great Britain to be a right at common law. The right to useful invention seems with equal reason to belong to the inventors. The public good fully coincides in both cases with the claims of individuals. The states cannot separately make effectual provision for either of the cases, and most of them have anticipated the decision of this point by laws passed the instance of Congress. Said another way, we want patent and copyright and trademark monopolies to be granted to the various folks that put them out there in the world because we want them to be incentivized to put them out in the world. Now, that doesn't mean that they can't go too far. That doesn't mean that patent trolls don't exist and that you can't actually use these monopolies on intellectual property to squelch or try to squelch competitive behavior, which is, I think, what people are reacting to when they say they hope Nintendo loses this case and things like that. But we don't really know what patents they're even seeking to prosecute on this point. So I would caution folks before they get to that step that we need to know what patents we're talking about. And I had held this video in the hopes that either Nintendo or PocketPair would release that information, but that didn't happen before this video. And I thought it was important enough to talk about the differences between copyright and patent with you all so that we could have better informed conversations out on the internet on this topic first and foremost. Now, PocketPair did respond to this, as I promised. They said a little bit more than a week ago that yesterday a lawsuit was filed against our company for patent infringement. We have received notice of this lawsuit and will begin the appropriate legal proceedings and investigations into the claims of patent infringement. At this moment, we are unaware of the specific patents we are accused of infringing upon, and we have not been notified of such details. And people ask me about this in my DMs and otherwise. And when I read this section, I read it as paperwork that's a little bit different than in the United States, where you'd have to be served with the complaint against you, and a complaint in a legal context has to tell you what you're accused of doing, right? In this case, it sounds like they get notice that they are a named party in the Tokyo courts. And as they are given that notice and it's a patent infringement claim, they know that much, but they haven't seen the complaint yet as of this time, September 19th, 2024. Now, I have every reason to believe they've seen it by this point in time, and there's probably a story there with respect to the fact that neither Nintendo nor PocketPair are actually releasing what patents we're talking about, but everything there would be speculative at this point. And so I don't want to speculate too much other than to say it does strike me that Nintendo doesn't share what patents it's talking about, presumably to keep the goodwill of their brand name and because they don't necessarily want PocketPair to just change the patented behavior in their video games and avoid getting into the weeds here with respect to this lawsuit. So that frames Nintendo in a negative light, and that may be unfair to them, that there's other reasons why they might not be sharing the patents with us. Certainly the fact that PocketPair also isn't sharing them is its own kind of negative light. But I did want to at least point out that the people that are guessing at these things are guessing without specific information from these companies themselves. They also, PocketPair says, we will do our utmost for our fans and to ensure that indie game developers are not hindered or discouraged from pursuing their creative ideas. And Nintendo fans that came out against this particular line said, well, you aren't helping indie game development if you're just stealing ideas. But we're probably not talking about PocketPair or someone else going into Nintendo's code and figuring out exactly how they do something that can be patented and then copying it in their own game, because that would be disastrous and that paper trail would absolutely kill them. Instead, we're probably talking about game companies and software companies in general that create a mosaic of patents that kind of cover everything that their software does, and that you can essentially accidentally trip into by developing things along similar lines, right? You can have ideas that are similar to ones in existence, and probably you didn't check every patent in Japan for something that could potentially be applicable to the way that you have solved this particular software problem. So I don't want people to just assume that PocketPair has stolen this, although I do at least empathize with the position that they were so close to some of the design vibes of Pokemon that you want to see them in a negative light on this score as well. We just truly don't know enough to go on those, on that particular description. Now, I also wanted to include a little bit more on patents from the USPTO. Again, this is a document called Demystifying the Patent System. Now, as you can expect from a USPTO or other US government document, this demystifying the basics of patent law is a short, svelte 46 pages long. We're not going to be going over every detail there, but we are going to be talking about a few things. The historical foundation of intellectual property we covered when we discussed the Federalist Papers. But what is a patent? It's the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. It is of a limited term, although some would argue that limitation is not nearly limited enough, and it is territorial. A U.S. patent provides protection only in the United States, no worldwide patents. Now, that's probably a little bit reductive. As I said before, when we look at Japan and we look at other countries in the world, for the most part, these countries have international law conventions between each other so that each can recognize the intellectual property of the other. We see USPTO even keeps a Japan file that says they are in line with the Paris Convention for priority of overseas IP filings, the Patent Cooperation Treaty for international patent applications, the Hague Agreement, and the Madrid Protocol, and among others. And I'm not a patent lawyer. One other disclaimer I would give is that the patent lawyers in the United States are actually licensed under a different bar than every other lawyer in the United States. It's a patent bar with specific patent rules that you have to learn and that are really more accessible for people with a scientific background or a mechanical engineering background or something along those lines, because it is such a specific kind of skill set. So we're going to see in just a minute what the claims of a bit of intellectual property look like, but they're going to look foreign even to me, let alone to you. So it's important to understand that patent law, even above other law, is a niche speciality. And so we are talking about these things as best we can without having that special expertise myself. So I wanted to say that as part of Japan. I also wanted to say the internet is a wonderful thing, and we can, in fact, do research on these various things. And a lot of lawyers have put up interesting information about their jurisdictions that we can go and read about. So this is from a company called YMF Law Tokyo that talks about the defenses to patent infringement in Japanese litigation. I thought this was particularly important to understand with respect to the lawsuit in Tokyo, because the defenses are pretty much the same as we might see in America. You can claim, if you're being sued for patent infringement, that you didn't infringe, that whatever you made doesn't infringe for reason X, Y, or Z, that the patent was essentially improvidently granted, that the patent should be deemed unenforceable because the patent office that put it out there didn't do its proper research, didn't follow the laws and regulations that were out there. And so the patent itself that you're being sued over shouldn't be something that you can be sued over, and then you can win because the patent is invalidated. And when we see other articles in just a minute talk about the fact that this is a risky avenue for Nintendo, that's what they're talking about, that the patents that are at issue here could be invalidated, or that others could see weakness in the Nintendo patent portfolio of some kind by seeking this particular pursuit. Now, I don't actually think that this is a particularly risky avenue for Nintendo, but you will see that in a couple of other headlines as part of this video. And I wanted to mention non-enforceability because this is where the really interesting thing in Japan comes up. One of the peculiar features, as summarized by this YMF Law website, of Japanese patent litigation is that the adjudication of a patent's validity in the first instance is reserved for a panel of examiners at the Japanese Patent Office. Historically, the labor of adjudicating patent infringement and patent validity was divided between the district court and the JPO. If an accused infringer wished to assert that the patent was invalid, its only choice was to initiate an invalidation proceeding at the JPO under Article 123 of the Patent Act. The district court was likewise resigned to press forward with the trial of infringement and damages issues, even where it was clear that the patent ultimately would be invalidated before the JPO. Said another way, in the United States, by comparison, you can get sued and in court say that the USPTO didn't grant this patent properly, that it's too broad, that there's prior art that exists that should invalidate it, et cetera, et cetera. But in Japan, the setup is slightly different, that the JPO is essentially the final arbiter of whether a patent is validly granted. And so if you go through the court system, as PocketPair is going to have to do with Nintendo, the district court, for the most part, is going to have to listen to the fact that the patent was issued in the first place. Now, this changed a little bit in 2000, as summarized in this particular web article. In Fujitsu versus Texas Instruments, the Japanese Supreme Court substantially resolved the dilemma by holding that the district court may entertain evidence concerning an asserted patent's validity and, as a matter of equity, fairness, decline to enforce a patent that has clear grounds for invalidation. So another way, they don't have to completely ignore the fact that this patent was improvidently granted, and they can say this lawsuit shouldn't proceed because the JPO is essentially going to invalidate it at some other point in time. But as you can imagine, that isn't as clear as the case in the United States, where you can just challenge these things directly in court. And as this article continues, it says it does provide for areas of gray probleming in the law because the JPO might not do exactly what the court thinks it's going to do. And you might have issues with that as well. And so we have an issue with the fact that this is in Japan. It's probably going to be harder to invalidate a patent, even if it was wrongly granted in Japan, than it might otherwise be in the United States. And Nintendo is, of course, a giant company in Japan, has Mario on the Japanese airport and things like that. And so if you're PocketPair, you have reasons to worry just based on the chip stack on the other side of the table. But we can say that this particular case is one in which the patents may be challengeable depending on what they look like. So let's take a look at what that might mean. So one thing I did want to give a hat tip to is a tweet that I saw from Gen of Hatred TM, probably not trademark, but who knows, at Genbox360 on Twitter/X. If you're wondering why Nintendo are suing PocketPair for patent infringement and not copyright, this is an interesting snippet from Bloomberg. And Bloomberg's article on this score is paywalled, so we're not going to look at that directly, but we are going to look at an article that discusses it. Nintendo filing this lawsuit for patent infringement, not copyright violation, means it has given up making the case that PalWorld's characters are similar to Pokemon's, said Toyo Securities analyst Hideki Yasuda. Now, I wouldn't put that quote just that way. I don't know that they've given up, but I think in a legal analysis like the one we did here in Virtual Legality earlier this year, the lawyers at Nintendo probably said, this is kind of a pie-in-the-sky attempt. If we're going to try to sue them for copyright infringement, it's not obvious that they stole assets. You can't copyright an idea. You can't copyright a vibe, just like you can't patent an idea. You can't patent a vibe. You can only patent the execution of the concept. But this particular analyst comes to a conclusion that is similar to mine, saying that Nintendo would prefer to have a copyright violation because they can just axe PalWorld off the face of the planet. And that the fact that they aren't doing that suggests that they didn't find something that they could sue on that over. But this analyst continues, it shows Nintendo has more ways to stop games it doesn't like. The company owns a lot of patents related to basic game mechanics that are used in many titles available today. And I do think this is part of the story. Again, I wouldn't frame it exactly the same way, but part of the story to me is that PalWorld did fly close enough to the sun to get Nintendo's attention. It was hugely successful. The designs of the pals are very evocative of Pokemon, even if they aren't identical, even if they aren't stolen assets. And if you rub a company that has a patent portfolio or just a huge amount of money on their side of the table the wrong way, this is when that sword of Damocles can start to hang over your head. We talk about it a lot with respect to Twitch streamers or other streamers in the live space or people that make reaction videos to various things in video games. But for the most part, a lot of those uses are technically violative or would seem to be technically violative of intellectual property laws. And you are living at the largesse of these companies to some extent. Now, this is a different issue, but it is a similar kind of concept that Nintendo probably doesn't bother you if those designs are a lot different or even a little bit different and don't evoke Pokemon and have journalists constantly saying Pokemon with guns to describe your game. But since that was the case, even if they can't get you on copyright infringement, they might try to find another way, and that does appear to be what happened here. And that's a part of the story itself. I did want to catch a few other things in this patent summary before we get too far. There's a couple of different types of patents, utility, design, and plant. Design here is one thing that we can't just throw out the window. It's possible Nintendo has the equivalent of a design patent on some ornamental feature of the Pokemons that is copied in PalWorld. We just don't know because we don't know what patents we're talking about. But everybody is assuming, and I think probably accurately, that we're talking about utility patents. Patents on inventions, the function of things in a mechanical sense. Yes, it's software, but it's still a mechanical sense when we talk about it. The USPTO is great. Why invention matters, what this means to you. Patents promote innovation and help safeguard your inventions. They help companies grow. They benefit the community by making new goods and services accessible, and they provide personal growth, development, and advancement. Now, you don't have to agree with all these policy prescriptions. This is the USPTO, of course, tooting their own horn about what it is that they do and why they get up in the morning. But the concept, as we discussed with respect to the Federalist Papers, there is that by allowing inventors to have this protection, we incentivize inventions on the whole, that more inventions exist because of that protection. And that further, because patents are public information, you're essentially getting all of this information and invention out there to the public, and the public can build off of it. So at least as patents are supposed to be functioning, the way that the Nemesis patent or whatever we're talking about with respect to the Nintendo patents here operate, it should be under the assumption that the fact that that has to be revealed to the public means that other people can build on it in a novel and new way and have their own patents and own inventions. If that isn't the case, then yes, they might be being granted incorrectly. We might be in our court system or the Japanese court system or any other court system allowing quote unquote patent trolls to essentially put up moats around things that should be simple and well understood. The patent application journey we can skip through. This is one that I wanted to capture because this is probably the most important aspect of what we're going to discuss with respect to Nintendo. When we're talking about patents, they have to be new. Is your idea novel and non-obvious? Novel. Your invention has to be new and not described in prior art. It can't be something that existed before. It also, and this is important, has to be non-obvious. The differences between your invention and everything that existed before you can't be obvious to someone with experience in your field, right? So when we're talking about things like throwing Pokeballs at somebody in a three-dimensional space, one could argue that that follows directly from the way three-dimensional space has been operated since at least, ironically, Mario 64. And so that probably isn't something that is deserving of separate protection, depending on how the claims are actually written. And that's the kind of thing that if you're PocketPair, you would bring up in court. But as I said, in Japan, it might be a bigger issue because the JPO apparently has already issued this patent as a continuation of a prior patent. And so it's not going to be as perhaps effective a defense as it would be in other jurisdictions. So those are all things that you're taking into account if you're sitting in on these legal board meetings and you've got lawyers on one side and you've got the developers on the other and you've got the board and the money people on that third side of the room, and they're trying to figure out what makes sense in terms of risk profiles and everything else, what to do. PocketPair's likely solution here is going to be to settle this because there's enough question marks in court and because PalWorld is worth enough money that it makes sense to give a certain amount of money to Nintendo in respect of it. But we don't know what we don't know, and we don't know the future, certainly, as we look at these issues. What is prior art? I think it's pretty self-explanatory, even for legal terminology, but it's everything that existed before you tried to make your invention. And then we got more on the patent application journey, but we will skip ahead to some of the other stuff we wanted to talk about. This is an article from, I think, The Gamer. Nintendo and the Pokemon Company's lawsuit against fellow creature collectathon PalWorld is for patent infringement rather than copyright infringement. And one analyst reckons that means Nintendo has given up on trying to argue that Pals look too similar to Mons. Do we call Pokemons Mons? I don't think I've ever heard that. Nintendo announced that it was filing a lawsuit against developer PocketPair earlier this week for infringing multiple patent rights in order to protect the valuable intellectual property that we have built up through many years of hard work. Nintendo had previously said it was looking into potential cases of copyright infringement right around the time when PalWorld became a booming success. So most people speculated that if a legal battle between the two monster tamers were to start, it would be centered around the creature design's visual similarities. I mean, I think that was really the only thing that really irked people was that it looked so much like Pokemon. But I do want to point out, as part of kind of journalistic integrity here, that Nintendo has previously said it was looking into potential cases of copyright infringement does not appear to be accurate to me. This link links out to Nintendo's original statement that said, we have received many inquiries regarding another company's game released in January 2024. That's PalWorld to you and me. We have not granted any permission for the use of Pokemon intellectual property or assets in that game. We intend to investigate and take appropriate measures to address any acts that infringe on intellectual property rights related to the Pokemon. We will continue to cherish and nurture each and every Pokemon and its world and work to bring the world together through Pokemon in the future. And I'm sorry, this wasn't from Nintendo. This was from the Pokemon Company. But you can see even here, we've got people that are just kind of trying to report on this on an objective basis, assuming that that discussed copyright infringement when all it talked about was intellectual property infringement, which incorporates patents and trademarks. So we do have these kind of light issues when we talk about journalism and reporting on topics like this. And hopefully videos like this one can help stamp out some of those inconsistencies and misinformation. Speaking to Bloomberg on the quote that we just looked at on Twitter, the Toyo Securities analyst Hideki Yasuda explains that since the lawsuit is purely to do with patent rights, Nintendo isn't going to bother arguing that Anubis looks too much like Lucario, for example. Well, they can't in the lawsuit that they filed, at least if it doesn't include copyright claims, and we have no reason to believe that they do. I won't pretend to be a legal expert, says this author, but from what I understand, patents normally protect someone's inventions, yes, like software or machinery, while copyrights usually protect someone's work. I mean, I could go further than using normally and usually there. That's what they do, like books, music, and art. Details about the case are still under wraps, so no one really knows what Nintendo will argue. Now, one thing I don't understand about this story is why Japanese journalists haven't been able to go into the Tokyo filing system and find this, but it is possible that in Japan, they just aren't made as publicly available as they are in the United States. Continuing on, that's all we had for that article. We do have some other things that are happening that I wanted to discuss with respect to guesswork and journalism, right? So with this big void as part of this story, Nintendo won't say what patents they're talking about. PalWorld won't say what patents they're talking about. We had a lot of folks interested in this story wanting to find out what patents we are talking about, because the very first thing that journalists realize is when we're not talking about a copyright infringement claim, we have to be talking about specifics. And so as we see in this IGN article, a lot of people went searching for what patents we might even be referencing with respect to Nintendo and the Pokemon Company. Here's IGN's article entitled Nintendo versus PalWorld. Killer patent may be about the mechanic of catching Pokemon. They say Kiyoshi Kurihawa, and I apologize in advance for my pronunciations here, a Japanese patent attorney and consultant on intellectual property, spoke to Yahoo Japan on the lawsuit and pointed to a killer patent that it revolves around the mechanic of catching Pokemon itself. And I also saw this referenced by Stephen Totillo, formerly of Kotaku, formerly of Axios, currently runs I think a Medium site called GameFile, which I do recommend. They have a lot of good information. He does a really good job. It seems it would be hard to avoid if you want to make a Pokemon-like game, and it's easy to infringe if you're not careful. Kurihawa Hara is quoted as saying, in general gameplay terms, PalWorld's survival and crafting mechanics are more like those of Ark than Pokemon. Yes, one thing that jumps out at you is that PalWorld plays nothing like a modern Pokemon game. After PalWorld's huge launch earlier this year, comparisons were made between PalWorld's pals and Pokemon, with some accusing PocketPair of ripping off Pokemon designs. But rather than file a copyright infringement lawsuit, Nintendo and the Pokemon Company have gone down the patent route. Kurihawa identified 4 divisional patent applications that Nintendo and the Pokemon Company jointly registered after PalWorld's launch in January. Now, this is important. A divisional patent contains isolated content from an already registered parent patent. So they have these patents filed, I think, in 2021. But you can go and you can narrow the claims. You can take what amounts to a large patent and say this is a different patent that is kind of the child of the above patent. And we are going to do this for a number of reasons, one of which is that you can sue over it without dragging in all this extra information or all these extra areas where you might otherwise get challenged. The patent Kurihawa believes is the focus here, 7545191, describes aiming a capture item, Pokeball, at a character placed on the field, a Pokemon, releasing the capture item in a direction determined by player input, judgment of whether capturing is successful or not upon contact between the capture item and the Pokemon, and changing of the Pokemon status to owned by the player when capturing is successful. In addition, the patent also covers the mechanic of having capture probability displayed to the player, regardless of whether it uses colors, graphics, or numbers. Now, here's where I think things get a little bit confusing for people. This is what we would call the abstract, right? This is the idea. The idea isn't actually patented. Much like copyright only protects the expression of an idea, when we talk about a patent, the legal bounds of a patent are only in what we call the claims under the patent. And we'll see how difficult those are to interpret in just a second. But this idea drives people crazy because they think, okay, they have protection on anybody throwing anything at a monster in the field, and then they can sue over it. And it's not exactly the case. They have to specify exactly what it is that they are patenting, how their software works, and they can write it too broadly and it should be invalidated. But mostly the claims should be very specific to the way this operates for their game. Now, you'll also note that some people came to me in my DMs or my messages and said, hey, Rick, if they have a patent and Pokemon is 30, 40 years old, how could that still be applicable today? And the answer is this particular one that we're talking about here is really only happening in Arceus and on, right? The earlier Pokemon games had you go into a turn-based battle, select a Pokeball, and get that Pokemon if certain mathematics met in your favor. In Arceus, you're actually out there in a three-dimensional field, and you're throwing a ball at something that you can see, and that might be the difference. This might be a winner for them, that what you've got in PalWorld, which is I think a Pal Ball. It might be something else, a Pal Sphere, I believe. Yes, totally different word than ball. A Pal Sphere that you throw at a monster might be too much. It might be the case that this does infringe the patent as viewed by Japan, as issued by the Japanese Patent Office. But you can pretty easily change this to, as Digimon does, having them fired into a card. Cassette Beasts has them become recorded on a cassette tape, various other things that can happen that maybe get you out of that infringement, maybe are okay with Nintendo. Yes, you probably have to pay a settlement fee to get this out of court at this point in time, but that might still be what PocketPair and PalWorld decides to do. And when we talk about things like this, we are only talking about these very specific things and not the game itself, which is why I said at the beginning of this video, I think you're looking at a game that can make a couple of changes and probably be fine. Assuming that the patents that we're talking about here and in other places are the ones that are actually at issue. We don't know that for sure, and there could be others that come into play that are troublesome for PocketPair. I'm particularly concerned about potentially a rendering technology that makes the Pokemon look like Pokemon and that PalWorld is too close to, something along those lines. But in this particular case, I can envision a small change to the game that largely keeps the PalWorld experience the same, but doesn't infringe upon Nintendo's protections. Patent number 7545191, alongside 3 related others, were only approved in August, which might help explain why it's taken this long for Nintendo to announce its lawsuit. The parent patent of the 4 divisional patents was registered in 2021, and thus, as translated, are legally effective against PalWorld, which launched January 2024. Yes, they have a big mosaic patent, presumably, that covers all the ways that Arceus works or whatever other game they would have done for this particular patent. And then they take little bits out so that they can sue like they did here against PocketPair. You don't have to love it. Nintendo's the big gorilla in the room on this particular story, but that's probably what happened here. And so the fact that they did make these continuations or divisional patents for these particular reasons might well lead us to believe that these are the patents being sued over, but we don't know for sure as part of this story just yet. It is worth noting that PalWorld does include a mechanic that involves throwing a ball-like object called a Pal Sphere at monsters out in the field to capture them, and this may prove the key to the lawsuit. Kurihara suggested Nintendo and the Pokemon Company filed the 4 divisional patents for specific use in litigation against PocketPair. As for PocketPair, it said it will begrudgingly investigate the patent infringement claims while continuing to update PalWorld despite the lawsuit, and apologized to players left concerned about the future of the game. Now, the one thing I want to say here is that I do think that journalists had probably jumped a little early on this, and I would be more focused on trying to find the complaint document itself than do this kind of analysis. But I can't begrudge them for looking for news that people are clearly interested in, and this is that type of news. So I wanted to have that discussion with you here in Virtual Legality, because I do think there are dangers here. We could be talking about completely different patents. But the fact that these did get continued after PalWorld was launched, I think, is suggestive of the fact that these might well be at issue. Or, as Eurogamer put it, it's exceedingly plausible Nintendo crafted patent claims to specifically target PalWorld, says IP expert. Developer PocketPair is currently being sued. Well, that's just true. And then we look at this article and we see much the same as what IGN put forth. Those particular claims are the ones at issue. And then certainly in the last week alone, we've seen that PalWorld launched on PlayStation 5 and that it is not launching on PlayStation 5 in Japan. Now, this headline, again, probably goes one speculative step too far for my comfort. Nintendo lawsuit halts PalWorld PS5 release in Japan. Suggests that a lawsuit was filed that enjoins the release. That isn't, in fact, the case. This is essentially speculating that the existence of the patent lawsuit that we're looking at today is what caused PocketPair to not release it on the PlayStation 5 in Japan, which I think is probably a decently sourced bit of speculation in general. If you're accused of violating intellectual property rights, you don't want to go the step further and willfully violate those rights now that you're on notice that there might be a violation out there, right? You have plausible deniability until you're sued. Once you're sued, you've got an issue with, okay, now I'm just deliberately infringing your rights. And the way most intellectual property laws are written around the world, once you get into that willful infringement kind of level, you have much bigger penalties, much higher exposure than you would before that point in time. So you don't have to have a mental state to infringe on an existing patent, but if you do have that mental state, things could be much worse for you. So I do think when we talk about whether or not PalWorld releases on PlayStation 5 in Japan, it is probably the case that Nintendo saw this was going to happen and issued this particular lawsuit in order to have this kind of result. But I don't think we can make a definitive headline as DualShockers does here. Now, as I have criticized a number of articles in the way that they've reported on this in this video, I do want to give credit where credit's due. I've mentioned that I am not a patent lawyer, and I do think it is always useful to get insight from specific lawyers and specific people with expertise in the stories that we're talking about. And PC Gamer did, in my opinion, the best job that I've seen doing my research on this particular topic in an article they called "A Video Game Patent Lawyer Breaks Down Nintendo's Risky PalWorld Lawsuit." It definitely feels like a punishment. And I think you've seen now a number of lawyers, including myself, say it does in fact feel like Nintendo is bringing this particular claim against this particular company because they do think that they flew too close to the sun, that they were trying to bank on the goodwill that the Pokemon brand generates, even if they're not specifically violating a law on that particular issue. And they brought this patent lawsuit for that purpose. But more importantly, and I will link this as I do on the podcast page to this episode because I can't link it on YouTube anymore because YouTube gets mad at outside links. But if you go to the podcast link that will be a part of the description of this video, you will see this link directly, or you can look up the headline I just mentioned. This particular lawyer goes through a lot of the details here. In fact, so much of what he says would be pertinent to our conversation that I didn't wind up highlighting anything because it would have been just all highlighted. But PC Gamer asks, we don't know what Nintendo's specific allegations are yet, but what should readers understand when they hear patent lawsuit as opposed to copyright infringement? Well, a lot of it hinges on the definitional concept of what different forms of intellectual property protect, says Kirk Sigmund, which you learned or already knew earlier in this video. At the very highest level, there's the copyright side of things, which is creative works, books, music, movies. And that covers a lot of the video game area. That includes code. The software code is essentially the same as the words on the page in a book. That includes pretty much anything creative, and it's intentionally quite broad. A copyright lawsuit can, and oftentimes is, be related to a lot of different creative things in the game space. A patent lawsuit is different because what that means is that someone has to have granted and issued a patent in some country. In this case, they're Japanese patents. So at some point, Nintendo went to the patent office during the development of a video game or console, and they filed a patent on some concept they think is new, novel, and non-obvious. Countries differ on their definitions, but generally speaking, it can't be abstract ideas. It cannot be creative works. It cannot be brands, which are covered by copyright and trademark, respectively. It has to be unique to the patent system. And they also had to convince the patent system in Japan, America, wherever they did, that what they did is not only new, but would be non-obvious to what we call a person of ordinary skill in the art. So this is all stuff that we've talked about prior in this video, but it's important, and this lawyer is doing a good job of breaking it down. In Nintendo's case, they've been pretty fastidious about making sure that a lot of their concepts, where possible, make it into some sort of patent. There's this very famous one they did back with the N64, where they made what I jokingly called the omnibus patent. They put in everything from what the controllers look like to how they operate, to how the 64 operates, to how the processors in N64 operates, how Mario moves, how he goes from one world to another, everything in one big patent. And I think they only got like one set of claims out of it. But the big thing to understand is that this lawsuit is dictated by the terms of the patents they're asserting. They cannot claim, oh, you knocked off the vibe of Pokemon. You've got to show that whatever is defined by those Japanese patents they're asserting is literally and directly infringed by PalWorld, which brings us back to another picture that we were just talking about. So it's not like Nintendo's got a patent on the general idea of catching monsters, says PC Gamer, right? It's a fairly narrow scope when you're asserting a patent. Oh, absolutely, says the lawyer. The big thing that people tend to mistake is that they pick up these patents, they read them, and they think, oh my God, this covers everything. In reality, what the patent covers is dictated by what are called the claims. And in the Japanese patents, the ones we think they're asserting, the claims are quite lengthy. And they link to the claims as part of this article. We're going to take a look at them because we're going to see how hard they are to read, even for just non-patent lawyers rather than human beings. But the abstract is what gets people. In a first mode, this is the aiming in a virtual space determined by a second operation. This is where you catch things with Pokeballs. But here's how it actually reads in law. What is claimed is 1, a non-transitory computer-readable storage medium having stored therein a game program that when executed by a computer of an information processing apparatus causes the computer to perform operations comprising switching between at least a first and second mode based on a first operation input, and in the first mode, determining an aiming direction in a virtual space based on a second operation input, and causing a player character to launch in the aiming direction an item that affects a field character disposed on a field in the virtual space based on a third operation input, and when the item is launched at a place where the field character is disposed, giving an effect associated with the item to the field character, et cetera, et cetera. And this goes on and on and on, and is very difficult to read to the layman, let alone the non-patent attorney. And there's a lot of things that can come up where if you bring this claim and you bring this lawsuit, various people can say, well, that shouldn't have been granted because that's too broad. There is prior art, right? The notion of throwing something at something in the field existed before, and so this patent shouldn't have been granted. The notion of capturing something and something that you threw at it existed before, so this shouldn't have been granted. There's a whole host of things that you can argue here. When you are filing for a patent in any jurisdiction, you are supposed to disclose to the patent office what the prior art is, but reasonable minds can differ as to what is prior art on some of these inventions, and you can get into fights over those things. Certainly in the United States, I would expect to fight over various aspects of the claims here. I can't speak to that with peculiarity in Japan, but here we are. And so the claims are very difficult to read. They are the only bounds with which the law applies. The abstract doesn't really matter for purposes of this, but there's a whole host of things that affect the expression of what we're talking about here, right? How the system works. This is what the processor is configured like, just randomly picking a claim in 29 here. When the fight against the field character is 1, set a limitation on movement of the field character, et cetera, et cetera. And while you can have infringements that are only partially covered by the claims, you're going to start to get into arguments in court about whether or not that's a full infringement or not. So the bounds in the law are set by these claims as granted by a patent authority in some jurisdiction. And so Nintendo is going to have to prove that the infringement happened on that score. But if we assume that they can, you still have defenses that we talked about with respect to even Tokyo and Japanese law. How closely does PalWorld have to resemble the claims in the patent to qualify as infringement? Does Nintendo have to prove that there was an intent to infringe? Or is it truly the case if PalWorld checks all these boxes, that's infringement? The lawyer says more or less the latter. That's just what I mentioned. Essentially, you don't have to have mens rea, a state of mind, to infringe to get into trouble here. Those claims are listed and are made public so that if you do hit all those boxes, then you can be sued for infringement. It is a checklist, as this lawyer says. When a video game company is drafting a patent filing, how much accounting for scope do they have to do? If your attempted filing is overbroad, will it just get thrown out? Or is that something that tends to shake out in lawsuits afterwards? Well, that's where it gets really interesting, says the lawyer. Part of your job when you're writing these patents is to know if you go too broad, they will get destroyed in litigation. They really should be destroyed at the regulatory patent office level, but that is not always the case. If someone can go find an example of something that's prior art, they can prove that the patent should never have been granted in the first place. If you go too broad, they can just unwind the whole patent. Your job, to some degree, is to weave the delicate balance between going overly narrow, allowing everyone to freely knock off your idea because you described it so narrowly that the other ideas don't apply, and going too broad where you don't get the patent at all. If you're too broad, then you've given them a pathway to make the patent go away, but you've given them an opportunity to prove that it was already in existence because of that. Now, what you've touched on is very important because at least in the United States, you have mechanisms to go after these patents without them enforcing them against you. We have declaratory judgment actions through the court system. We have what are called IPRs. In both cases, you can go, hey, patent office, you were wrong. You shouldn't have granted that. Let me prove why you shouldn't have. As a fun example, someone once tried to assert against Blizzard, or Blizzard tried to assert against somebody. Regardless, the IPR devolved into them citing Dungeons and Dragons manuals at each other to try and prove that technically this whole concept was not new because it was in there. Now, I have to say, in my experience talking to patent lawyers, discussing software patents and other related intellectual property with my clients, it is never as fun as arguing Dungeons and Dragons manuals in court or otherwise to each other. That is not the practice of law. If you say, Rick, it sounds fun to argue Dungeons and Dragons manuals, so I'm going to become a lawyer, don't do that. Or at least don't do it because of that reason. Don't say Rick told me to because I get to argue about Dungeons and Dragons. That is unlikely to be your career path in the law if you do become a lawyer. And that's where this might pan out. If Nintendo asserted one of these patents and they've gone overly broad, they may have exposed themselves to PalWorld finding proof that these concepts are not new. Because this is drafted fairly broadly, even in Japanese, you can get clever about the games you're looking at as prior art, what references you're looking at. You can always whip out Dungeons and Dragons because that's always a good example of how characters interact in role-playing games. And also it's very, very broad. You'd be surprised how often you can make those arguments. They've exposed themselves in a big way. Now, I disagree with this. I don't think they are exposed in a big way on this particular score, but I do think they're exposed in the arena of goodwill, right? If these patents come out and Nintendo is trying to squash what has proved to be a hugely popular product in PalWorld just because of throwing a Pokeball out in the field or something similarly kind of broad to the gaming audience, I think they do stand a chance of losing some of their goodwill and seeing this as a negative overall. And I think that's one of the reasons they might have held back on what they're actually suing over. Is there a similar mechanism in Japanese patent law to invalidate a patent being asserted against you? Oh yeah, not only is it a defense, but it's quite powerful. Unfortunately, I've not seen any newer data, but the last study I saw back in, I think, 2015 said something like 70 or 80% of those cases lost for invalidity reasons. That means at some point a Japanese case was brought for infringement and the court decided, or the jury decided, that the patent should not have been granted. But in the Japanese courts, in the Japanese patent office, it's quite a bit more permissive than potentially in the United States. So we've got a permissive patent issuance. We've got potential issues with the way the courts review the patents and their validity. This person does say that he's seen a high percentage of those lost for invalidity reasons. I haven't seen that anywhere else, so we'll take that with a grain of salt. But certainly, I like this article. I like these quotes. I like this discussion with this lawyer. I'm very happy that PC Gamer went to this step to do this on what I think is an important issue. And so I will recommend that folks check it out. You don't just have to take my word for it on these topics. I always recommend second, third, fourth, 10th opinions on these things. And so check out this PC Gamer article because this lawyer does appear to pass the smell test for knowing what they're talking about, in my opinion. So that being said, this has been Virtual Legality for today. I want to make sure I capture any membership, super chats, or anything else that I might have missed while I was just talking about law at you for an extended period of time. And also, if you wind up having any questions or comments at this point in time, please do let me know because I would love to get to them. I love having these conversations with all of you here in the space. I hope this was helpful. Again, I think PalWorld will survive this, but it's important to note the difference between copyright and patent. It's important to note exactly what is being claimed here, at least in the broad strokes, because we can't talk about the specific patents at this point in time. Now, that all being said, let's get to some of these comments. So just because, thank you for being a member for more than 2 years. Yay, Hoeg. Yes, if you are looking at my list of videos, I haven't made a video in this space for more than a month. It's been a long month for me here. I very much appreciate everybody that has popped into this space today. We have over 200 folks at something like an hour's notice on a Friday going into your weekend. So I really appreciate everyone being here. It's just proven to be a very kind of long month here. I don't know if you can tell just from the video camera now, but this is a completely different setup. I have a mic arm now. I have a different desk. I have a different location in my office, even though I've tried to make it look mostly the same. And so I appreciate everybody that has bared with me through this period in time. Thank you. Thank you so much. Derek Thaxton, thank you so much for gifting a Hoeg Law membership. Every bit of support to the channel helps me make these videos, and I promise to continue to try to make them on topics of interest to me and to you on an even more regular basis than I have been doing this summer and the past year. I really want to get back to it, and I really enjoy these conversations. And just because, same thanks to you gifting 5 Hoeg Law memberships. That is super generous. I really, really appreciate it. Derek Thaxton, thank you for the $4.99 super chat. I hope you didn't mean to leave a message there, but if you did, let me know and I will try to find it in the chat. And thank you for becoming a YouTube member. David Hollinger, $5 super chat. Also, Nintendo is known for trying to patent everything they do to the point that every game company likely violates a Nintendo patent. That's certainly a part of this conversation, right? One of the things I did look at with respect to video game patents in Japan in particular is this kind of concept that many of the Japanese companies go for this mosaic patent approach to take everything that they concepted out in the creation of a video game or console or whatever it is that they're doing in the space and put out patents that cover every little bit of it. And then when they go to sue, make continuations or divisional patents or whatever they're called in any given jurisdiction and have them targeted directly at what it is that they want to sue over. So you can feel however you like about those things. I think overall patents are a good idea. I think overall intellectual property protection does help increase the creation of intellectual property in the world, but that doesn't mean that they can't go too far. That doesn't mean that maybe patents and copyrights are held as monopolies for too long for their owners. There's all sorts of policy arguments you can get into on these things. I don't blame anybody for complaining about the Nemesis system being locked up or for Nintendo doing this to PocketPair, but I do think the specifics here are important, and we don't yet have those specifics at this point in time. So with that all said, I do want to capture any other questions, comments, or things that are going to be asked here in the questions or comments section. Sardanisms does say YouTube did not give me any notice, and my phone is on Do Not Disturb, so it was sheer dumb luck I got here at all. Thank you. YouTube does not always give notice. I do recommend to folks that like this content and like this channel that you do check to make sure you are still subscribed, because YouTube does take you off my subscription list from time to time just on its own recognizance. Maybe because it thinks you're a bot. I really don't know. But please do check that out if you aren't getting notices and you wanted to get them. There's a lot of buttons to hit to make YouTube happy on that score. Again, if you are listening to this after the fact, leave comments and let me know if there's any questions I can answer in that format, and I will try to get to those when I can. As for the questions about, is the squeaky door still squeaky? Yes, we have not otherwise oiled the squeaky door. So if someone needs to come in and open the door, it will remain squeaky. I appreciate the question. Okay. Witness says you're looking great and I envy your focus. Smiley face emoji, thumbs up emoji. Well, thank you. That is very nice of you to say. Believe me, one of the blocks here in getting this video done was that I had so many things I wanted to talk about that I was essentially getting lost in the weeds a little bit, that I didn't want to miss anything that I thought was necessary to have this conversation. And if you think about things for too long, you wind up getting into a little bit of analysis paralysis. And I think I did that a little bit while I was waiting for someone to come out with what patents we're actually talking about. So thank you very much for the kind words. Sinya, thanks for the stream, Hoeg. You are appreciated. Have a good weekend. You too have a good weekend. See you on the Bitcast on Sunday. Absolutely. If you like to have these conversations, you got a preview of this conversation on the Bitcast last Sunday, where I talked about this particular issue for a very brief time at the end of that episode. I love talking about video games with my buddies Ains and Ty Guy Travis of IGN on this channel, and more importantly on the Seasoned Gaming channel. So if you like these conversations, they're not all going to be about law. They're mostly about what we're playing, what games are coming out, and those kinds of things. Check out the Bitcast, 11 a.m. Eastern time on Sundays, and I will see you there. I love the Bitcast. Love my friends. We have great conversations, and I love it. Jalaire Golightly asks, wait, no more law books is a microphone stand? No, look, I can look at it's all bouncy now. No, this was my wife's idea. So one of the things that I had to do this year was close my downtown Northville office, because essentially post-COVID, people weren't really that interested in coming downtown, weren't really interested in meeting with their lawyer rather than Zoom calling or phone calling them. And so it just didn't make sense to spend that rent money anymore. But it did mean that I had a lot of office materials and desks and things that had to be taken care of. So we moved the office essentially here. And then my wife said, well, let's fix up some of this stuff, and got me an arm. And then we've got another monitor here that I will eventually be adding so that I can look at all of your wonderful chats at the same time that I am speaking all this legal nonsense. But we'll see if we ever get up to that speed. Sardanisms with the Hoeg Law question. Thank you. And if you do want to have your question answered, please do try to flag it with an @Hoeg Law or a Q and a question mark or somewhere else that I can see it. Of course, I'll try to answer super chats and member comments, but I got a lot of chats and I don't always see everything. So please do let me know. Sardanisms asks, would changing the game design right after a lawsuit is filed not be used as evidence of wrongdoing? You would change it as part of your settlement agreement with Nintendo. You wouldn't change it uniformly right now. It would be evidence, well, it wouldn't be evidence of wrongdoing insofar as you can say, I still didn't know that it was infringing. I looked at your infringement claim and then decided that I thought it was, and that might be used against you, and you wouldn't want to make that choice at this point in time. But you could say, hey, look, Nintendo, we'll pay you this amount of money. We'll change it to a PAL square, PAL cube, if you would prefer. If that would make you happier, it'll be a cube instead of a sphere. And see what they do with that, and come to a settlement agreement that says we're going to make these 6 changes. We're going to pay you this amount of money as a check, and then all of this stuff is going to be let go. You're never going to bring this claim for this infringement again, and we're going to move on with our lives. We're going to make money. You're going to make money, and now you know what people actually want from your Pokemon games, and maybe you can get on some of those design improvements as well, right? And that's what would happen. So, Emily, thank you for being a member for almost 2 years. Love some Hoeg to kick off the weekend. Yeah, well, we've got a Michigan game tomorrow. Michigan not having as great a year as it did last year, but still a fun team to watch. And I love my weekends in the fall for that reason. We've also got the Apple Orchard open here in Southeast Michigan. If you're familiar with apple cider and spiced cinnamon donuts in Michigan, I would recommend Parmenters of Northville. But please do check it out if you're ever in the area, because it's what makes fall special here. Papa says 2 monitors. Yes, indeed. 2 monitors. I know it would be crazy, right? I think Rob has 4 or something. in his space. But he jumps all in with this stuff. Cactus asks some important questions on my background. What are the boxes to the left of your head from your view? Is that Eldritch Horror? No, that is a game from Restoration Games called Unmatched. I think I don't know if it's Restoration now. I think it is called Unmatched, where you take things from usually literary and public domain areas and have them fight each other in tactical battles, like Achilles versus Sherlock Holmes, or the Invisible Man versus the Raptors from Jurassic Park, what have you. And I really enjoy it. They have a lot of different things to play as. I think the one that's new on the shelf as of this change in background is there's one with Shakespeare and like the witches from Macbeth that you can add to the fight if you're so interested. And they all mix and match with each other. And I highly recommend that game. Benjamin Luna asks, will this become a precursor for other companies to now patent certain game mechanics found in their own games? They already have been. Every game company has patents on various things. Generally speaking, Nintendo is not going to come after companies that are just out there doing things on their own because it would look bad for them for the most part. But I think in this particular case, so many people expected them to sue that they actually had that statement that you saw the Pokemon company make, and Nintendo was looking into it. And I would argue that what you saw from the analysts that suggest that Nintendo was irked by the way the designs read to the populace is probably accurate. And if you irk a company like Nintendo and they have this big portfolio of intellectual property already secured, they might well find a way to come after you. I don't think it is as strong as people wanted with respect to a copyright infringement claim and getting PocketPair for stealing the design of Pokemon. But Nintendo seems to be motivated by wanting to punish PocketPair on whatever score they can find. Emily says, oh, I love an apple orchard. Great childhood memories. I love apple orchards. They're open here from like Labor Day to like Thanksgiving. And they're just wonderful experiences. They have little playgrounds. They always smell fantastic. I have apple cider. I am going to go drink after this video is done. And now that we've talked about it a little bit, I am more excited about it than ever. But yeah, they are great memories. Newspin, I have a hard time thinking PalWorld can't win this. Other games have such similar mechanics. Temtem is turn-based and has cards instead of balls. WoW has pet battles, also turn-based. So again, remember when we talk about the patent itself, we're talking about the specific expression of the idea. It's not the concept of throwing something and capturing it on a kind of broad basis. It's being in a three-dimensional space, seeing a monster in front of you, and actually affecting the throw of the ball, having it hit the monster in space, having a little bit of an animation to figure out whether you captured that monster and then it coming into your possession or not. And certainly that one small aspect of PalWorld is very similar to the way Arceus and Scarlet and Violet currently play. And that might be a case where Nintendo could have a good claim against them, but not the overall concept of capturing monsters, right? That's not what we're talking about. That's what the lawyer in the PC Gamer article was mentioning. People think about it in the abstract like that. That is not as what it protected. Only the specific expression, and in fact, even deeper than that, only the way the software actually comes up with how to establish that expression, how the processors work with each other, how the inputs from the player interact. And so you could change any small aspect of this, and if it's materially different from what is in the claims under a Nintendo patent, then you are likely not infringing. Now, at this point in time, you may well be infringing, and you'd have to agree to some kind of settlement with Nintendo that the court would approve of, but it probably doesn't require material changes that would change how you experience PalWorld to get out from under the shadow of most of the stuff that we've seen rumored right now. Now, there are other possibilities for patents that we don't know yet that could be a bigger deal, but that's part of why I keep disclaiming that we don't know what patents we're talking about yet. All right, and I think that's about it for questions pertinent to the topic at hand. I said this in the Twitter message, but I wanted folks to know that this will be available in replay archive immediately after this video is over. So please do check that out. And again, likes are very helpful. Subscribes are very helpful. Comments, dislikes are even very helpful. YouTube dislikes it when it knows you're alive and not a robot. So let it know, leave comments, share this video around with people you think might find it useful. And I really appreciate all of the support from everybody in this community every time I make a video. So thank you so much. And I will see you on the next Virtual Legality, Hangouts and Headlines. Who knows? Maybe even the Bitcast this Sunday. Thank you again for being here, and I will see you on the next one.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.